First Amendment, ratified on December 15, 1791. Freedom of religion, speech, press, assembly, and petition. The First Amendment prohibits Congress from making any law that establishes a religion or restricts the free exercise of religion. It also protects freedom of speech, freedom of the press, the right to peaceably assemble, and the right to petition the government for a redress of grievances. This amendment forms the core of American civil liberties, ensuring that citizens can express themselves and advocate for change without fear of government retaliation. Original text: Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Second Amendment, ratified on December 15, 1791. Right to keep and bear arms. The Second Amendment protects the right of individuals to keep and bear arms. It states, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. This amendment has been the subject of significant debate and interpretation regarding the extent of firearm regulation permissible under the Constitution. Third Amendment, ratified on December 15, 1791. Quartering of soldiers. The Third Amendment prohibits the government from quartering soldiers in private homes during peacetime without the homeowner's consent. During wartime, soldiers can only be quartered in a manner prescribed by law. This amendment was a response to colonial grievances against British practices and ensures citizens' privacy and property rights. Original text: No soldier shall, in time of peace, be quartered in any house, without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Fourth Amendment, ratified on December 15, 1791. Protection from unreasonable searches and seizures. The Fourth Amendment protects individuals against unreasonable searches and seizures by the government. It requires that any search or seizure be conducted under a warrant issued by a judge or magistrate, supported by probable cause and specifically describing the place to be searched and the persons or things to be seized. This amendment aims to protect citizens' privacy and prevent abuse of government power. Original text: The right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. Fifth Amendment, ratified on December 15, 1791. Rights in criminal cases. The Fifth Amendment provides several protections for individuals accused of crimes. It guarantees the right to a grand jury, prohibits double jeopardy, being tried twice for the same offense, protects against self-incrimination, being forced to testify against oneself, ensures due process of law, and mandates just compensation for property taken for public use, eminent domain. This amendment is crucial for ensuring fair treatment in the legal system. Original text: No person shall be held to answer for a capital, or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use, without just compensation. Sixth Amendment, ratified on December 15, 1791. Rights of accused persons in criminal cases. The Sixth Amendment guarantees the rights of individuals accused of crimes. It ensures the right to a speedy and public trial by an impartial jury in the state and district where the crime was committed. It also guarantees the right to be informed of the nature and cause of the accusations, to confront and cross-examine witnesses, to have compulsory process for obtaining witnesses in their favor, and to have the assistance of legal counsel for their defense. This amendment aims to ensure a fair trial and protect the accused from unjust prosecution. Original text: In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. 7th Amendment, ratified on December 15, 1791. Rights in civil cases. The 7th Amendment guarantees the right to a jury trial in civil cases where the value in controversy exceeds $20. It also ensures that no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. This amendment preserves the traditional role of juries in civil cases and protects against judicial overreach. Original text: in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. 8th Amendment, ratified on December 15, 1791. Excessive bail, fines, and punishments. The 8th Amendment prohibits the federal government from imposing excessive bail, excessive fines, and cruel and unusual punishments. This amendment is intended to protect individuals from disproportionate penalties and inhumane treatment. It ensures that the punishment fits the crime and promotes humane treatment of individuals within the justice system. Original text: excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. 9th Amendment, ratified on December 15, 1791. Rights retained by the people. The 9th Amendment states that the enumeration of certain rights in the Constitution does not mean that people do not have other rights that are not specifically mentioned. It was included to address concerns that listing specific rights might imply that those were the only rights protected. This amendment underscores the principle that the people have inherent rights beyond those explicitly listed in the Constitution. Original text: the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. 10th Amendment, ratified on December 15, 1791. Powers reserved to the states or the people. The 10th Amendment states that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. This amendment reinforces the principle of federalism by ensuring that any powers not specifically granted to the federal government are retained by the states or the people. It serves as a reminder of the limited nature of federal authority and the importance of state sovereignty. Original text: the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. 11th Amendment, ratified on February 7, 1795. Suits against states. The 11th Amendment establishes judicial limits by clarifying that states cannot be sued in federal court by citizens of another state or by citizens or subjects of any foreign state. This was adopted in response to the Supreme Court decision in Chisholm v. Georgia, 1793, which allowed such lawsuits. The amendment aims to preserve state sovereignty and protect states from certain legal actions in federal courts. Original text: the judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. 12th Amendment, ratified on June 15, 1804. Election of President and Vice President. The 12th Amendment revises the procedure for electing the President and Vice President. It requires electors to cast separate ballots for each office, rather than casting 2 votes for President. This amendment was adopted following the problematic election of 1800, which resulted in a tie between Thomas Jefferson and Aaron Burr. The revised process aims to prevent electoral confusion and ensure a clear outcome in presidential elections. Original text: the electors shall meet in their respective states, and vote by ballot for President and Vice President, one of whom, at least, shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president, and they shall make distinct lists of all persons voted for as president, and all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president, shall be the president, if such number be a majority of the whole number of electors appointed, and if no person have such majority, then from the persons having the highest numbers not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately, by ballot, the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the Vice President shall act as President, as in the case of the death or other constitutional disability of the President. The person having the greatest number of votes as Vice President, shall be the Vice President, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the Vice President. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of President shall be eligible to that of Vice President of the United States. 13th Amendment, ratified on December 6, 1865. Abolition of slavery. The 13th Amendment abolished slavery and involuntary servitude, except as punishment for a crime. This amendment was a direct result of the Civil War and aimed to formally end the institution of slavery in the United States. It marks a significant milestone in American history, promoting freedom and equality for all citizens. Original text. Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2. Congress shall have power to enforce this article by appropriate legislation. 14th Amendment, ratified on July 9, 1868. Citizenship, equal protection, and due process. The 14th Amendment addresses citizenship rights and equal protection under the law. It grants citizenship to all persons born or naturalized in the United States, including formerly enslaved people, and ensures that no state can deny any person equal protection of the laws. It also guarantees due process rights, preventing states from depriving any person of life, liberty, or property without due process of law. This amendment was crucial in extending civil rights and ensuring equal treatment under the law. Original text. Section 1. All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property, without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. 15th Amendment, ratified on February 3, 1870. Right to vote regardless of race. The 15th Amendment prohibits the denial of the right to vote based on race, color, or previous condition of servitude. This amendment was designed to protect the voting rights of African American men following the Civil War and the abolition of slavery. It aims to ensure that all citizens have an equal opportunity to participate in the electoral process, regardless of their race. Original text. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have power to enforce this article by appropriate legislation. 16th Amendment, ratified on February 3, 1913. Federal Income Tax. The 16th Amendment grants Congress the power to impose a federal income tax without apportioning it among the states or basing it on the U.S. Census. This amendment was enacted in response to the Supreme Court decision in Pollock v. Farmers Loan and Trust Company, 1895, which ruled that certain taxes on income were unconstitutional. The 16th Amendment allows for the collection of taxes on individual and corporate income, providing a significant source of revenue for the federal government. Original text. The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. 17th Amendment, ratified on April 8, 1913. Direct election of senators. The 17th Amendment established the direct election of U.S. senators by popular vote, replacing the previous system in which state legislatures selected senators. This change was part of a broader movement to make the government more democratic and responsive to the will of the people. The amendment ensures that each state has 2 senators elected by the people of that state for 6-year terms. Original text. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof, for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution. 18th Amendment, ratified on January 16, 1919, repealed by the 21st Amendment on December 5, 1933. Prohibition of alcohol. The 18th Amendment prohibited the manufacture, sale, and transportation of intoxicating liquors within the United States and its territories. This amendment marked the beginning of the Prohibition era, which aimed to reduce crime and corruption, improve health, and reduce the social problems associated with alcohol consumption. However, Prohibition led to unintended consequences, such as the rise of organized crime, and the amendment was eventually repealed by the 21st Amendment. Original text. Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. Section 2. The Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. 19th Amendment, ratified on August 18, 1920. Women's suffrage. The 19th Amendment granted women the right to vote, marking a significant milestone in the women's suffrage movement. This historic amendment ensured that women could participate fully in the democratic process and have a voice in government. Original text. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation. 20th Amendment, ratified on January 23, 1933. Commencement of terms, sessions of Congress, death or disqualification of President-elect. The 20th Amendment, also known as the Lame Duck Amendment, changed the dates for the beginning and ending of terms for the President, Vice President, and members of Congress. It moved the start of the presidential and vice presidential terms from March 4th to January 20th and the start of congressional terms from March 4th to January 3rd. The amendment also addresses issues related to the death or disqualification of the president-elect and the procedures for filling such vacancies. The goal was to reduce the lame duck period and ensure a more efficient transition of power. Original text. Section 1. The terms of the President and Vice President shall end at noon on the 20th day of January, and the terms of Senators and Representatives at noon on the 3d day of January, of the years in which such terms would have ended if this article had not been ratified. Section 2. The Congress shall assemble at least once in every year, and such meetings shall begin at noon on the 3d day of January unless they shall by law appoint a different day. Section 3. If, at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall become President. If a President shall not have been chosen before the time fixed for the beginning of his term, or if the President-elect shall have failed to qualify, then the Vice President-elect shall act as President until a President shall have qualified, and the Congress may by law provide for the case wherein neither a President-elect nor a Vice President-elect shall have qualified, declaring who shall then act as President, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a President or Vice President shall have qualified. Section 4. The Congress may by law provide for the case of the death of any of the persons from whom the House of Representatives may choose a President whenever the right of choice shall have devolved upon them, and for the case of the death of any of the persons from whom the Senate may choose a Vice President whenever the right of choice shall have devolved upon them. Section 5. Sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. 21st Amendment, ratified on December 5, 1933. Repeal of Prohibition. The 21st Amendment repealed the 18th Amendment, effectively ending the era of Prohibition in the United States. This amendment granted states the authority to regulate the transportation, importation, and distribution of alcoholic beverages. It remains unique as the only amendment that repeals another amendment and the only one ratified by state conventions instead of state legislatures. Original text. Section 1. The 18th article of amendment to the Constitution of the United States is hereby repealed. Section 2. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors, in violation of the laws thereof, is hereby prohibited. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. 22nd Amendment, ratified on February 27, 1951. Presidential term limits. The 22nd Amendment limits the President to 2 terms in office, or a maximum of 10 years if they assumed the presidency due to the death or resignation of the previous President and served more than 2 years of that term. Original text. Section 1. No person shall be elected to the office of the President more than twice, and no person who has held the office of President, or acted as President, for more than 2 years of a term to which some other person was elected President shall be elected to the office of the President more than once. But this article shall not apply to any person holding the office of President when this article was proposed by the Congress, and shall not prevent any person who may be holding the office of President, or acting as President, during the term within which this article becomes operative from holding the office of President or acting as President during the remainder of such term. Section 2. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by the Congress. 23rd Amendment, ratified on March 29, 1961. Presidential vote for Washington, D.C. The 23rd Amendment grants residents of Washington, D.C., the right to vote in presidential elections by allocating the district a number of electors equal to the least populous state, currently 3 electors. This amendment aimed to provide representation to the citizens of the capital, who previously could not vote for the president or vice president. Original text. Section 1. The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors of president and vice president equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered, for the purposes of the election of president and vice president, to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th Article of Amendment. Section 2. The Congress shall have power to enforce this article by appropriate legislation. 24th Amendment, ratified on January 23, 1964. Abolition of poll taxes. The 24th Amendment prohibits the use of poll taxes in federal elections. Poll taxes were fees required to vote and were historically used to disenfranchise African American voters and poor citizens. By abolishing poll taxes, this amendment aimed to ensure that the right to vote could not be denied based on an individual's financial status. Original text. Section 1. The right of citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress, shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. Section 2. The Congress shall have power to enforce this article by appropriate legislation. 25th Amendment, ratified on February 10, 1967. Presidential succession and disability. The 25th Amendment clarifies the procedures for presidential succession and dealing with presidential disability. It consists of 4 sections. 1. If the president dies, resigns, or is removed from office, the vice president becomes president. 2. If there is a vacancy in the office of the vice president, the president nominates a vice president who takes office upon confirmation by a majority vote of both houses of Congress. 3. The president can temporarily transfer power to the vice president by submitting a written declaration to the president pro tempore of the Senate and the Speaker of the House of Representatives, stating an inability to discharge the powers and duties of the office. 4. The Vice President and a majority of the principal officers of the executive departments can declare the President unable to discharge the powers and duties of the office. The President can contest this declaration, and if there is a dispute, Congress decides the outcome. Original text. Section 1. In case of the removal of the President from office or of his death or resignation, the Vice President shall become President. Section 2. Whenever there is a vacancy in the office of the Vice President, the President shall nominate a Vice President who shall take office upon confirmation by a majority vote of both houses of Congress. Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Section 4. Whenever the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the Vice President and a majority of either the principal officers of the executive department or of such other body as Congress may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Thereupon Congress shall decide the issue, assembling within 48 hours for that purpose if not in session. If the Congress, within 21 days after receipt of the latter written declaration, or, if Congress is not in session, within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of his office. 26th Amendment, ratified on July 1, 1971. Right to vote at age 18. The 26th Amendment lowers the voting age in federal, state, and local elections from 21 to 18 years old. This amendment was influenced by arguments that those old enough to be drafted into military service during the Vietnam War should also have the right to vote. This change significantly expanded the electorate and ensured that younger citizens could participate in the democratic process. Original text. Section 1. The right of citizens of the United States, who are 18 years of age or older, to vote shall not be denied or abridged by the United States or by any state on account of age. Section 2. The Congress shall have power to enforce this article by appropriate legislation. 27th Amendment, ratified on May 7, 1992. Congressional pay. The 27th Amendment prohibits any law that changes the compensation for members of Congress from taking effect until after the next election of representatives. Originally proposed in 1789 as part of the Bill of Rights, this amendment was not ratified until over 200 years later, in 1992. It aims to prevent Congress from granting itself immediate pay raises without accountability to voters. Original text. No law, varying the compensation for the services of the senators and representatives, shall take effect, until an election of representatives shall have intervened.